If you were born in the 1950s or 1960s, you grew up in a very different America. You grew up in a country where people were told rights were rights, not applications, not waiting periods, not permission slips from a local office that could say yes to one person and no to another. And now, after decades of states building permit systems around discretion, delays, fees, and approval processes, the Supreme Court has forced the country to confront a question that goes far beyond one gun case. Can the government make you prove you deserve to exercise a constitutional right before it lets you use it? That question matters to everyone. But for Americans born in the 1950s and 1960s, it hits differently. Because you are the generation most likely to remember when the rules were simpler, most likely to have lived through the steady tightening of permit systems, and most likely to be asking right now whether the Supreme Court just changed the game again. And here's the part most people still don't understand. This is not just about one permit. It's about whether the old model of gun licensing can survive the legal direction the court is now setting. If you want straight, no-nonsense breakdowns of Supreme Court rulings, gun laws, and the real-world changes they create, subscribe right now. This channel is built for people who want clarity before the headlines get twisted. Now, let's get into what this ruling actually means, and why older Americans should be paying especially close attention. Let's start here. Why specifically people born in the 1950s and 1960s? Because you are the generation now moving through retirement, traveling more, relocating more, protecting property more, and thinking more seriously about self-defense than you may have at 25 or 35. You are also the generation most likely to have lived under multiple different gun law eras. The old local discretion era, the post-Heller era, the post-Bruen era, and now the next phase, where states and courts are still fighting over what permit systems can legally look like in the future. That matters, because if you got your permit years ago, or were denied one years ago, or stopped applying because the system felt stacked against you, the Supreme Court's decisions are not abstract legal debates. They go straight to one practical question. Has the government's power to control who gets to carry been permanently reduced, or is it just being rewritten in a different form? And that is where this story gets very serious. The major turning point was New York State Rifle and Pistol Association versus Bruen. New York required people to show proper cause, basically a special need beyond ordinary self-defense, if they wanted a license to carry a handgun in public. The Supreme Court struck that down. In a 6-3 decision, the court held that the Second Amendment protects a right to carry a handgun in public for self-defense, and that New York's discretionary proper cause system violated that right. The court also changed the legal test for gun cases. When conduct is covered by the Second Amendment's plain text, the government now has to justify restrictions by showing they fit the nation's historical tradition of firearm regulation. That was the earthquake. Because once the court said ordinary citizens do not have to prove some special need beyond self-defense, every state that built its system around discretion had a problem. But that's only part of the story, because a lot of people heard that ruling and immediately jumped to the wrong conclusion. A lot of Americans heard about Bruen and thought, that's it, permits are over. That is not what the court said. Justice Kavanaugh, joined by Chief Justice Roberts, went out of his way to note that states can still use objective licensing systems, things like background checks, fingerprinting, mental health record checks, and firearms training, as long as they are not based on open-ended discretion and a demand that citizens prove some special need apart from ordinary self-defense. That distinction is everything. Because the court did not say government can play no role at all. What it attacked was a very specific model. The model where the state acts like a gatekeeper, deciding whether your reason for wanting to carry is good enough. And here's what most people are missing. Once that model is weakened, states don't usually give up. They adapt. They rewrite. They relabel. They move the restriction to a different part of the process. And that is why this issue is still moving right now. This title says the ruling could change gun permits forever. That word, could, matters. Because the change is not only about what the Supreme Court already struck down, it is also about what the court has now made legally vulnerable. Before Bruen, states had much more room to defend permit rules under balancing-style constitutional arguments. After Bruen, the government has to do something harder: show historical support for the restriction. That new framework does not just affect one New York law. It affects future challenges to licensing rules, disputes over where permit holders can carry, fights over private property defaults, and the broader question of how much friction a state can build into the process before it starts looking like disguised denial rather than regulation. As of 2026, the Supreme Court has also accepted more Second Amendment cases for review, showing that this area is still active and still evolving. So if you are in your late 50s, 60s, or early 70s, and you think the rules you learned 5 years ago are still the rules that will govern the next 5 years, that is a dangerous assumption. Because this is not settled in the everyday sense. The rulebook is still being rewritten in court. Now here's where the story gets more complicated and more important. Some people believed the Supreme Court was on a straight-line path toward wiping out one gun law after another. Then came United States versus Rahimi. In that 2024 case, the Supreme Court upheld the federal law disarming people subject to certain domestic violence restraining orders. The court said there is historical support for temporarily disarming individuals who pose a clear threat of physical violence to others. Why does that matter for permit holders? Because it tells you something crucial. The court is not saying every firearms restriction is automatically unconstitutional. It is saying the government has to justify restrictions under a new, history-focused framework. That means this is not a story of all permits disappear or nothing changes. It is a story of legal pressure, pressure on discretionary licensing, pressure on broad carry restrictions, pressure on states that built permit systems designed more to control ordinary applicants than to screen for objective disqualifications. And for seniors, that distinction matters a lot. Because your next renewal, your next move to another state, your next travel decision, or your next application may happen in a legal environment that looks very different from the one you first learned. Let's make this real. If you were denied years ago and never applied again, the legal environment may no longer look the way it did when you were turned down. A denial that once felt final may have happened under a system that later came under serious constitutional pressure. If you already have a permit and think nothing changes for you, that is exactly the kind of assumption that gets people blindsided. Even if your permit remains valid, the rules around renewals, carry locations, private property, and travel can shift as states respond to the Supreme Court and as new cases move through the system. And if you travel more now than you did 10 years ago, retirement travel, seasonal living, visiting children and grandchildren in other states, all of that increases your legal exposure. The worst mistake you can make is assuming one Supreme Court ruling made all state laws the same. It didn't. The real danger is not only misunderstanding what changed, it is continuing to live by old assumptions after the legal map has already started moving. So what should this generation be watching now? Watch what your own state does after major Supreme Court rulings. Some states comply quickly. Others try to preserve the old result using new language. Watch the next wave of cases, because the court has more Second Amendment decisions in the pipeline that will further define the boundaries of gun restrictions and licensing rules. And stop assuming the issue is simply for or against guns. That is how television talks about it. The real legal fight is over how far government can go in turning a right into a managed privilege, and how much procedural control states can keep before a court says they crossed the line. That is a much deeper issue, and it is not going away. If you were born in the 1950s or 1960s, this matters to you, not because the court created some brand new right out of thin air, but because it is redefining how states are allowed to burden a right that millions of Americans have exercised for generations. Bruen struck a major blow against discretionary permitting and changed the constitutional test for gun laws. Rahimi showed the court is still willing to uphold some restrictions under that framework. And the next cases will likely tell us even more about what the future of permits, carry rules, and state power really looks like. That is why this could change gun permits forever. Not because everything ended overnight, but because the legal logic behind old permit systems is under deeper pressure than it has been in decades. If this helped you, drop a comment with your state and tell me whether you think your state is adapting to these rulings or trying to work around them. And if you know someone born in the 1950s or 1960s who still thinks the old permit rules are the whole story, send this to them. I'll see you in the next one.